Both American and English common law systems developed on USA and the UK respectively, two of the most representative federal states in the world. But farther than that similarity, there are some relevant differences between these countries and each legal system. USA, or United States of America, has a federal and constitutional republic form of government, while the UK, or United Kingdom, instills constitutional monarchy parliamentary governance. The USA has a president who leads the government and the state and is elected personally by all the Americans. He developed his role as administrator and selects certain secretaries in various areas, all under the code of an already set constitution. On the other side, the UK has a monarch who acts as the head of the state, but also has a prime minister and a chamber of ministers, a separate head of government that exercise political powers defined by the custom and tradition, with no written constitution.
Concerning the court systems in both the UK and US legal systems, the court systems are very similar to one another. Minor criminal and civil offenses are handled by magistrate courts, which are often referred to as state courts in the US. For more serious crimes or civil cases, the Crown Court in the UK or the District Court in the United States will handle these cases before being passed onto the Courts of Appeal and the Supreme Court if necessary. One of the major differences between the court systems in the UK and the United States is that the fact that the US does not have a tribunal system like the UK has in place for certain types of disputes. Instead, the United States has a specific court of bankruptcy, etc. Concerning the juries in the UK are selected at random as British residents who are between the ages of 18 and 70 and on the electoral roll are eligible for jury service. Jury duty must be honored, and only in exceptional circumstances will people be allowed to miss jury service. In contrast, the American rules for juries are pre-selected and are then agreed upon by counselors for both the defense and prosecution terms.
The last difference between the legal systems of the United States and the United Kingdom that we're going to talk about is the qualifications needed to practice law and the different titles of those practitioners. In the United Kingdom, there are two types of legal practitioners: barristers and solicitors. Solicitors are the ones that do the job of what is generally known as a lawyer in other countries. They advise clients, draft legal documents such as contracts, and attend meetings and negotiations. In order to become a solicitor, you need to go through three main stages: an academic stage, which consists of a qualifying law degree; a second stage consisting of undertaking a legal practice course that can be taken in a university and that will help you develop the necessary skills; and a third stage consisting of a training contract, which means working for a qualified institution as a trainee solicitor for 2 years. Barristers, on the other hand, are the ones that represent clients judicially and that can appear before all courts in the United Kingdom. In order to become a barrister, you need to go through three main stages too: an academic stage, which consists of a qualifying law degree; a vocational stage consisting of a 1 year of full-time study where you're taught advocate skills; and a stage known as pupillage, consisting of 12 months period where you work with an already practitioner barrister. In the United States, there is only one type of legal practitioner known as lawyer. In order to become one, you need to attend college and obtain a bachelor's degree, which is a 4-year academic program in a concrete area. Although no specific bachelor's degree is required, those that develop skills such as writing, logic, and public speaking can be useful. Then, you need to fulfill a 3-year academic program of legal courses to obtain the title of Juris Doctor. And lastly, you need to earn your license by getting admitted to the state where you want to practice bar association.